afternoon, everyone, and welcome to Skills Hub Session 7. So, before we begin to today's session, let's start by acknowledging the country. So, we acknowledge, recognize, and respect the elders, families, and forebears of the Gadigal people of the Eora Nation, who are the traditional owner of the land where Sydney is located. So, while studying in Australia can be a great opportunity not just to earn, but also to gain a valuable experience. However, it's equally important to understand your workplace rights and know how to protect yourself in professional environment. Today's session will help you navigate common employment situation from understanding your pay and payslip to know your workplace right. And to guide us through this, we are very pleased to have with us Mr. Aayam Shrestha, our Deputy CEO, a qualified lawyer with expertise in employment law. He's also passionate about supporting migrant workers and advocating for their right. So please help me and let's welcome Mr. Aayam.
Thank you very much, QD, for that warm introduction. I guess I'll just share my presentation and then we will begin. So can everyone see my screen? QD, can you see it on yours?
Yeah, we can see it.
Great. Okay. Yes, I'd just like to start again by the acknowledgement of country. So we acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land in which we meet today. We pay our respect to the elders past and present and extend that respect to all Aboriginal and Torres Strait Islander people. So for the agenda today, we have half an hour. And so these are the kind of 6 things I want to share with everyone in attendance today. So firstly, we'll highlight, the issue of migrant worker exploitation in Australia. And you'll see that it is, a very pervasive and a large issue right now. We'll briefly explain some of the reasons why this exploitation happens and why it continues to subsist. We'll identify at a high level the legal framework that governs the workplace rights, migrant workers' status in Australia. We'll go through some of those rights and entitlements, and then I'll direct you to some resources you can use to get a better understanding of those rights. And then at the end, I'll quickly go over how, if anyone needs assistance, you can contact me for pro bono advice. So we have a lot of slides to get through. So if any questions come up, I would kindly ask that you hold them to the end and then just pop them into the chat. And then at the end of each slide, QT, if you could just, feel free to interrupt me and read out any questions. I'll do my best to answer them. So yeah, just quickly, who am I and why listen to me? So yes, I'm Aayam Shrestha. I have a lot of experience entangling with Australia's employment law context. I worked at a trade union, the Rail, Tram and Bus Union, which is the ones that are responsible for all of the train strikes and, why some of you get to Sydney Met late sometimes. So I've represented over 50 people, included migrant workers who are being exploited in the workplace. Currently also employment law solicitor at Orbis Legal, and previously when I was a law student, I did some volunteering within the Kingsford Legal Centre, which is a community-based legal centre that provides representation to vulnerable members of society. So I have a bit of experience and I'd like to share with you what I've learned, and hopefully it can be valuable to everyone tuning in today. So first things first, migrant worker exploitation it's not a side issue. It is a serious issue right now in Australia. It's one of the biggest issues with regard to employment law and workers' rights at the moment. So there's been some research done by Berg and Farbenblum recently that has demonstrated that international students are being underpaid $3.18 billion in wages every year. So this was a survey of 10,000 migrants in Australia, and a quarter were even underpaid by at least $10 an hour. And that's roughly equates to about $61 million every week. And some other important statistics that demonstrate the severity of the issue is 65% of migrant workers were paid below their individual, their legal entitlements that's governed by the Fair Work Act. And we'll get into that in later slides. 36% were paid below the minimum wage. The average underpayment was $8.80 an hour. 35% of migrants worked on an ABN. So this is one of the kind of loopholes that employers use to facilitate the exploitation. And I just want to recognize right now that the exploitation is not just limited to underpayment. Yes, underpayment is the most common and biggest form of exploitation, but I'd like to also respect the fact that it takes many different forms, such as bullying, discrimination, sexual harassment, and more. Yes. So why does this exploitation happen and why does it continue? So there's a myriad of reasons that are outlined in research, journal articles, publications. But the three most common that I have found is number one, for international students specifically, the vulnerability of students. And that mainly entails the financial pressure, such as the need to keep up with tuition and survival costs. And then some research from the Gradden Institute actually has identified the working hours restrictions that's embedded into your student visas as one of the things that perpetuates the exploitation because you only have a certain limited hours to work, and you don't want to speak up to your employer because you want to retain those hours and pay your costs. The next one that links to that is employer control and fear, and this is most specifically for anyone in here that's under a sponsorship arrangement. And in that same survey that I outlined in the last slide, the most common reasons that people weren't standing up for their rights was fear of losing shifts, immigration consequences, being reported to authorities, and so on. And then the last reason, what I've seen representing, over 50 people, is just the lack of awareness of their rights. So sometimes, maybe you or international students are unaware that the exploitation is even happening. They work, money is coming in, it's enough to cover the bills, and this is the interesting point: is the money that you're earning is comparatively much more than how much you would earn back in your home country, because of the favorable exchange rate. But you are being exploited, but you're not aware of it. And then leading on from that is you're unaware of, if you do find out you're being exploited, what are the avenues for justice? Where do you go? And then also some misconceptions of what your rights are as a migrant worker, maybe thinking that they differ from the rights of a citizen or permanent resident who's a worker. So here's a image that I created using AI, and this kind of goes towards the second point of employer control and fear. An international student checked the legal entitlements, found out they're being underpaid, and then their boss saying, if you say anything, threatening them that they'll lose their job, and then they'll try to cancel the visa. So this is a very common, unfortunately, it's a very common scenario that happens in Australia. Okay, and the next point to make is that the exploitation is deliberate and structural. This means it's embedded into the system and it's intentional by employers. So some hidden ways that exploitation shows up and that you might not even be aware is missing records, so lack of pay slips and documentation, which are, it's a legal obligation of businesses to provide pay slips, to provide a written contract, for example. Misclassification to your correct award category. So we'll go over what modern awards are. But a modern award generally has the different pay structure according to your role. So it could be A1, A2, A3. And if the business identifies your skills and the role is at an A3 level, they'll intentionally pay you at an A1 level, which might be a lower rate. ABN arrangements, this is known as sham contracting. So when you're told to get an ABN, then businesses try and engage you as a contractor. So it's a business to business relationship, as in you the worker are the business, even though the characteristics of the relationship, by all intents and purposes, remain like employee employer. And the reason they do that is because if you are a contractor, there's a lot of entitlements you don't have to pay. Things like overtime rates, and that's essentially because you won't be subject to the award. So we'll go over that in the next slide. But interestingly, the survey that I put on Bergen-Farbenblum's research, they identified that it is definitely it's not a gap, it is the system. So it's definitely intentional and structured. And again, going back to the point on the last slide, because you lack the knowledge of what your rights and entitlements are, you're not aware to these little nuanced, subtle methods that employers are using to exploit you. Okay, so just quickly, let's go over the legal system in Australia. So at a very high level, you have the Fair Work Act, which is it sets out the minimum standards for all employees. So it is the base standard that applies nationwide to basically all businesses. There are some nuances in terms of state employers, so the New South Wales government, for example. But generally, the Fair Work Act governs the legal rights and entitlements for all businesses and all employees. And then when you get a bit more specific, you have something called a modern award, which is made under the Fair Work Act. It's made under the Fair Work Act. And this modern award, you can think of it like a document that sets out the rights and entitlements for every industry or sector. So it's very sector specific. And then when you go a bit deeper, some organizations have something called an enterprise agreement, and that's very specific to an enterprise. So what usually happens is a union or a group of employees will negotiate with the business, and they'll make their own specific set of entitlements, and that they'll apply to the Fair Work Act, Fair Work Commission for approval. And then you have the employment contract. What's interesting and important to note is that the Fair Work, they set the minimum rates, and then the modern award cannot go below the minimum rate set out in the Fair Work Act. So it has to be, usually all modern awards have more specific clauses and entitlements. And then you also have higher rates than the Fair Work Act. And then same with the enterprise agreement, it'll be more specific entitlements and obligations. And then that will usually be higher than the modern award. And with your individual contract that you get, you cannot go below what's most relevant, I think, to everyone here is the modern award. You cannot go below. So if the modern award says, for your role, you should be paid $28 an hour, you can't, the contract cannot be below $28 an hour. That would be illegal. I'm not sure if there's any questions so far. QT, if there is, please interrupt me and I'm happy to answer.
Yeah, so there's no questions so far, so maybe we can do it just at the end.
Sure. So yes, like I was saying, the most relevant to the people in attendance today will be the modern award. So all of you, including myself, were covered by a modern award. And like I said, they set out the minimum entitlements and rate for your sector and industry. So this includes your classification and base rate, your shifts, including casual loading if you're engaged as a casual, overtime rates, and penalty rates. So this is, for example, like penalty rates are if you work on a public holiday, for example. Your time, so break, rosters, and minimum engagements. And then there can be other specific sets of rights and entitlements to the industry. Sometimes the modern award doesn't actually have anything specific or a rate that's higher than the Fair Work Act. So if any of you have ever viewed a modern award, it will just have a line that says defer to the Fair Work Act. So take an example here of a student who works as a waitress in a cafe. She will be most likely covered by something called the Restaurant Award. However, you have to do careful research because it's not so clear cut. There are many different modern awards, and many different modern awards could apply to one business depending on the role. So if we can click the link here. Can you see my screen, Cutie?
Yeah, we can.
It's the website, right?
Yeah, that's correct.
Yeah, so you can see for a cafe, it seems like a simple business, but many modern awards could have potentially apply. The Restaurant Award could apply, the Fast Food Award could apply. There's other awards, Hospitality Award, Registered Clubs, Amusement Award. So it's really important that you do your research and find out which one applies to you. And I'll show you how you can do that in a simple way in the next couple slides. And just quickly, so we can see what the structure of an award looks like, I'll open the Restaurant Award up here. And so you can see this is what basically all modern awards are structured like this. So your types of employment and classifications, hours of work, wages and allowances, penalty rates, and so on and so forth. So let me go back to the slides. Okay, QT, can you see my slides again?
We can also see your notes.
Oh, okay. Okay, sorry. Bear with me. Okay, sorry. How about now?
Yeah, we can see your slides.
Yep, good. Okay. And a misconception that I kind of briefly alluded to earlier was thinking that, because you're on a visa, student visa in particular, that you have less workplace rights than permanent residents and citizens. This is one that I came across a lot when I was representing people, and it is just not true at all. You have the same workplace rights and entitlements as permanent residents, as citizens. Your visa status does not change that, nor does it change your ability to access remedies available. If you go to the Fair Work Commission, for example, the award, the specific award that applies to your role, applies to you just as it would a citizen working in the exact same position in the exact same company as you. Of course, the only limitation with your student visa is the fortnightly working cap, but all the entitlements and the obligation that the business has towards you are the same. And another kind of misconception here is that the employer can cancel your visa even if they sponsor you. That's not right. That's something I came across a lot as well. Only the Department of Home Affairs has the authority to cancel your visa. And interestingly enough, even if you have breached your visa conditions, if you have a claim against your employer for underpayment, for example, you can still pursue the claim even though you've breached your visa under something called a workplace justice visa. I can talk more about that in later slides. Yes, so finding the modern award that applies to you, this is really critical. And there's a great tool published by the Fair Work Ombudsman called the Pay and Conditions tool. So you just do a Google search, Pay and Conditions tool, and it asks you a set of questions that will help you find your award. So I encourage everyone to use this online. But also, I love AI. I use AI, so you can also use AI, but you have to fact check. I would recommend giving ChatGPT the links to the different resources that you find and saying, this is my circumstance. Review these documents. Find what award is most applicable to me. Now, what do you do once you correctly identify your award? That's a good question. So, number one is you would want to compare the rate that you're being paid, maybe the rate that's in your contract or given to you via payslips, or what actually hits your bank account every pay cycle, with what your the correct classification is within the award. And then if it matches up, that's good. That's what we want. If not, then potentially there's an underpayment, and probably it's a deliberate underpayment. Not all the time. The award system is a little bit tricky to navigate. Not all businesses have, the employment law HR expertise, but generally it would be deliberate because, like I was alluding to before, that it is, deliberate and systematic exploitation. Overall, check to see you're getting the right entitlements, outside of right entitlements under the award. Break times, overtime, shift lengths, for example, is a common one that's specific to awards. So different awards will have different stipulated shift lengths. And then I would also just encourage everyone to go through the award generally and look at the different sections and understand what are my rights, in totality, and what obligations does the business have towards me. So this is the same guy, this image here, who stood up to his boss before. So he would be reviewing the modern award against his contract. And these are the three things he found: that he's getting his contract rate is less than the award, he's not being paid overtime, and his shifts are longer than the award allows. Is there any questions, QT, or shall I move on?
Yep, you can go ahead, continue.
Great. Okay, so we'll just get into some basic rights and entitlements. So minimum wages from the 1st of July have been updated. So the adults rates, sorry, the adult minimum wage is now $26.44. For casuals, it's a bit higher because you have something called casual loading, which is 25% more than the minimum wage for permanent employees, 12% super, and then there's special rates that apply, and those would be dealt with mostly in the awards. And I mentioned before that the awards are higher than the Fair Work Act, and this is established in the Fair Work Act. So these are the base minimums that would apply to everyone, but your award rates would be higher than this. So every time the minimum, a way to think about it is every time the minimum wage is updated within the Fair Work Act, Fair Work jurisdiction, the award rates will also generally are updated as well. Okay, here's a question: is cash pay illegal? This was something I came across. A lot of migrant workers, international students being paid completely in cash. Whilst cash pay is not illegal, it doesn't remove the obligations from the business in terms of how to lawfully pay employees. So the correct pay, so the correct rate still applies. You have to provide payslip, tax and super still have to be dealt with correctly. And if there's no records, if it's just pure cash payment, then that is alarm bells and red flags. What if you agree to be paid less? So, an employer comes to you and says, this is the rate, and you say, yep, I'm happy. Let me start Monday. You agreeing to be paid less doesn't make it unlawful. Like I said before, a lot of times the award system is difficult to navigate. You might not be aware of what you're owed under the award. So it's the employer's duty that they pay you as per your award classification. There's no discount. They can't pay you less because of your visa status or your level of English. And things like unpaid trials and deductions are only applicable in a limited set of circumstances, and that too will be governed by the award. Can my employer cancel my visa if I complain? Again, no, employers don't have the authority to cancel visas because they're not the one issuing the visas. So only Department of Home Affairs can cancel a visa. And complaining is actually a workplace right that is embedded within the Fair Work Act. So if an employer takes action against you because you made an inquiry about pay, then the employer is actually open to a claim, something called adverse action. And then again, the workplace justice visa, I touched on it before. There are certain set of circumstances that are required for someone to be able to get the workplace justice visa. One of them is that you had a visa that had some working rights to it. But for international students, all of you have working rights. It's just the fortnightly cap. Can I request flexible work? Yes, you can. There were new amendments to the Fair Work Act. And that means if there's amendments to the Fair Work Act, that means that applies to all awards as well, because the Fair Work Act is like the standard, it's the Bible of the employment law context in Australia. So there are certain conditions that you have to meet. So it's not a guaranteed result. So usually you have to be employed for 12 months. There has to be a relevant reason for requesting flexible work, whether you have caring obligations, you're over a certain age. And then there's certain employer obligations in terms of how they reply to the request. So one of them is that they have to reply in writing within 21 days, and that if they don't follow the process or it's an unreasonable refusal of your request, then you can actually take action in the Fair Work Commission. Yeah, I alluded to this before, but can you be punished for asking about pay? No, because asking about pay is a fundamental workplace right that's embedded in the Fair Work system. And so when an employer takes retaliation against you for exercising a workplace right, this could be making a complaint that's not about pay as well, or engaging in strikes, that's a workplace right too, then this is what we call adverse action. So the employer has taken action adversely to you because you exercise your workplace right. Adverse action applies to other things as well. If you're being discriminated, bullying, harassment, and then if you want to apply to Fair Work, there is a 21-day deadline that applies. Here's another one I came across a lot. Can I be forced to work on a public holiday? And the answer is no. employers cannot force you to work. For instance, they cannot just roster you to work on a public holiday. They must request. They can only request an employee to work on a public holiday. And this rule came out of a case not too long ago where this BHP, the coal company, was rostering employees to work on Christmas and Boxing Day. And then the federal court found that, no, you can't do that. You can only request them to work. And then the court also outlined, what are the different criteria that makes up a request. And then the company was eventually ordered to pay around $100,000 in compensation to the employees. QD, I'm assuming no questions, so I can continue?
Yes, please.
Yes, okay. What if you've been a casual employee for a long time and you want to become permanent? So under the provisions of the Fair Work Act, there is something called the casual conversion provisions. And again, because it's embedded within the Fair Work Act, it means it's also embedded within the awards. So there are conditions set out in this section I put on the slide, 15A. There's a minimum employment period. It has to be not casual in practice. So there's a regular pattern of work. So if you're working the same shifts week in, week out, you don't have a current dispute with the commission, and that you request it in writing. So there are, if you've been a casual for 2 years now and you've been working the same roster, then I would encourage you to consider potentially becoming permanent, because when you're permanent, you have a bit more rights and entitlements, such as accessing the leave provisions. Yes, and it's really important that you keep evidence from day one. So, your contract, the award that applies. If you're starting a new job, make sure you know which award applies. Maybe even ask the employer, do you know what award governs my employment? Take screenshots, keep your pay slips. That's really important, of course. Bank deposits, your time. Take screenshots of your rosters, start, finish times. Text messages, emails that are relevant to your conditions as well. So, for example, if you inquire about, your meal breaks, and then your boss replies to you via email, keep that screenshot, because they might be saying something that actually is not aligned with the award. And it's really important you get everything in writing. So even if your boss talks to you verbally, gives you confirmation, I recommend just send an email, send a text that follows up, just confirming X, Y, and Z. Because later on, if anything happens, all of this could potentially be evidence when you're pursuing a claim. Some places to go for help there. So the government regulators, of course, are the Fair Work Ombudsman, which is the Fair Work Ombudsman. You can go to their website for information. And the Ombudsman itself takes legal action against businesses. And the Fair Work Commission is kind of like the court or specialist tribunal that is set up for you to pursue a claim with your representative. So they have commissioners, which are judges that hear a claim. So if you've been, for example, unfairly dismissed, you could look at the Fair Work Ombudsman for information online, and then you'll take action within the Fair Work Commission. For legal help, there's a couple ones that I know of. The Employment Rights Legal Service is a free legal service based in Redfern. Migrant Workers Centre is newly established and represents migrant workers' rights. A trade union specific to your role, somewhere that I've worked before, and the International Students Employment and Accommodation Service. There is, luckily enough, there is a whole list of organizations that can provide assistance to you. So if you'd like the list of that, I encourage you to go on the Migrant Justice Institute website. They have a subpage called Where to Go for Help, and it basically lists all the different places you can go, to seek advice, to seek free representation. So what should I do if something looks wrong? So confirm, contact, take action. Confirm the underpayment by checking your payslip against the award, calculate what the total underpayment is, or if it's other forms of exploitation, collect evidence. That could be via emails, letters, text messages. And then at this point, once you've collected all of this, contact a representative at one of these organizations. You can seek help. You can contact the Fair Work Ombudsman. You could contact your applicable union, one of these community legal centers, or a pro bono lawyer who can assist you by reviewing your claim. It's really important that you get this reviewed by someone, because oftentimes it could look wrong, but it might be legally correct. So And then take action. So take the relevant remedial action that's advised by the representative after you've contacted them. I do not recommend doing it yourself. The system is tricky. Not only is the reviewing the awards and the Fair Work Act difficult, it's difficult for lawyers as well. The Fair Work Commission has their own set of procedures as well. So if you don't have a representative, there's a big barrier to your access to justice. And that employers are really smart and usually have access to very expensive lawyers. So you want to make sure you have the help of a professional. Just to close off, I do some pro bono work as well. So I may be able to represent you. I do this through a law firm called Orbis Legal. So feel free to contact me, and I may be able to help you, give you some preliminary advice, subject to my availability. And after an engagement, there's a written engagement, I can potentially represent you as well. So thank you very much. That's the end of the presentation. If anyone has any questions now, feel free to
Thank you,
ask away.
Aayam, for the very informative session. And I highly encourage students to ask questions now if you have any. Yeah, so Justin has raised his hand. So you can just, or do you want to clap? If you have any question, you can just put it in the chat box. We'll read it out for you. And our CEO is happy to assist you. So if
Sure.
not now, then I have a question for you, Aayam.
Sure.
So as we know, a lot of students, international students, they also work in cash, right? But working in cash is not illegal, as you mentioned in one of your slides, but there should be a proper timesheet and all. But what if a student or international student is not paid, even though there's an agreement in cash? Is there like any way she can reach out to? Is there any way the Fair Work can refer or help him or her out in those situations where the employer is not paying them in cash?
Yeah. Yes. I mean, if the agreement is to be paid in cash and you're not getting paid at all, then yeah, that is fundamental. That's not just underpayment, that is no payment. So the fundamental relationship of work is, you provide expertise and time and you get paid. So if someone is not getting paid cash at all, let alone, getting paid cash, but not getting paid, not being given pay slips and things like that, then yes, you could seek help from the Fair Work Ombudsman. They're very helpful. But if that's the case, then yeah, you should seek help as soon as possible from a representative.
Just adding to that, so if when should we realize it's a red flag if the payment isn't received? So normally we have days when payment is supposed to be come through, right? So is there any deadline that if the payment is not received in certain time frame that we need to reach out to Fair Works?
Yes, I mean, look, I think it depends on the history that you have with a certain employer. So let's say, you're used to getting a payment hitting your bank account every Thursday, because a lot of employers have automated payroll systems. So if on the Thursday you don't get paid, I would recommend just waiting, because sometimes there are some errors with the automation system. But I think, 3-4 days to 1 week maximum is a red flag. But at that point, I would be reaching out to the employer, putting everything in writing in an email. Hi, I haven't got paid for last week. Can you please remedy the issue as soon as possible? And then, if there's no reply to that, then that's when you would seek help from a representative.
Oh, thank you so much for answering those questions. And if students, if you don't have any questions, then we shall end the session today. So thank you so much again, Mr. Aayam, for agreeing to do this wonderful session. I hope to see you in more sessions, in future sessions for Skills Hub with more in your expertise. So students, thank you so much for joining. See you in our next session, which will be on Tuesday. So thank you everybody for joining, and thank you so much, Aayam. See you all. Bye.
Thank you, everybody. I hope you got value out of this. Take care. Thanks, Cutie.
Thank you so much.
Bye-bye.